So, hi everyone. So, today Supallab and I, we've gathered here on a Saturday morning to take you through how India's journey has been when it comes to data protection. Data protection, as you would know, is the key catchphrase that we are so often seeing, especially the young lawyers amongst us. So data is everywhere now, right? So why don't we take some time out today to see how the Indian laws govern data protection and how we as young lawyers can, on the aspects of data, which is a very nuanced field of law, and it goes in tandem with corporate laws also. When we deal with clients, one very peculiar question we often have to deal with is, does India even have a data protection law? What is it there that India does when it comes to data privacy? Because when we look at our counterparts in the EU, GDPR is such a prominent legislation, it is everywhere. But when it comes to India, it is not common knowledge that we've actually had data protection laws since 2011, really. So it will be interesting to for you guys to see how India has gone about shaping its data protection laws. Yes, it needs its own set of refinements and all, and therefore we may see the new digital personal data protection bill 2022 soon. So let's dive right in. What is data and what is personal data? Data is any set of facts. But what is personal data? Personal data is data which relates to a natural person, an individual that relates to all of us. Personal information also has a particular categorization to it. Specific data sets which are more sensitive in nature, maybe like your bank account number, maybe your medical report, those will be categorized as more sensitive sets of personal data. Hence, what we next see is what is the Indian legislative framework when it comes to regulating personal data and sensitive personal data. One important factor that we have to keep in mind here today is that at present, India does not have a dedicated data protection legislation, but we have aspects of data protection being covered under the Information Technology Act of 2000. So, in this IT Act of 2000, there are certain sections, and then subsequent to such sections, some rules have been introduced which attempt to govern sensitive personal data and personal data. So, to begin with, like I've pointed out, right now, we don't have an exclusive legislation, but that may soon change. And then we also have certain sectoral regulations applying, especially governing the insurance sector, the financial sector, which is regulated by the RBI. Personal information, like I pointed out earlier, would be information that helps somebody or a company to identify a particular person. Like if you have my name, if you have my email ID, my phone, my contact details, you can use these data sets, you can merge these data sets, and you will be able to gauge that yes, all this information pertains to Sharmana Devi. This is her information. So this is personal information. Coming to sensitive personal information, like I said, sensitive personal information is categorized and is specific to certain data sets which are more critical, and securing such information is more important than maybe your name. Like it is also logical that I would definitely want to secure my bank account number more than my name. I think if my bank account number today goes out in the public domain and gets misused, that will be a bigger threat to me than my name being misused in any way. So this will kind of basically give you an idea, a sense of why today we have specific rules to govern sensitive personal data, and maybe on the personal data front, the rules are not that developed yet. So coming to personal data again, yes, so like I said, the Information Technology Act of 2000 has certain sections which deal with personal information and sensitive personal information. When it comes to personal information, the unique thing about this is that the law does not prescribe any compliance mechanisms when it comes to collection of personal information from an individual in the first place. The only consent requirement that stems out from this is when we attempt to disclose that information to a third party, maybe without having taken that information providers' consent. So Section 72A of the IT Act primarily says that when there is an attempt to disclose personal information of an individual to a third party, but then the information provider has not consented to such disclosure, then an attempt to disclose such information can be intentional also, and it can cause me wrongful loss, or it can cause the information provider wrongful loss and wrongful gain to me who's attempting to disclose the information. So in this case, what the IT Act suggests is that before you're able to disclose personal information to any third party, make sure you take consent from the information provider. Information provider in this context would mean the person whose information is in question here. Also, the law has not prescribed any particular mode for taking this consent, and therefore businesses today have devised practical solves for going about this, where they give check boxes on their website to take consent. And then again, if you're unable to take consent, then obviously there will be certain penalties that will apply. The more important segment of India's current data protection laws is sensitive personal data or information, which includes the following that you can see on your screen. It will include one's passwords, biometric information, sexual orientation, physical, physiological, mental health conditions, medical records and history, and financial information, which will include your credit card, debit card details, bank account information, etc. Yes. So Section 43A of the IT Act is specific to sensitive personal data or information, and it says that any body corporate, that is any entity that is handling sensitive personal data, collecting, processing, dealing with SPDI in any manner, should implement certain reasonable security standards and procedures. And if the same is not done, then again, uncapped compensation can be allowed, can be provided to information providers who are aggrieved on account of the body corporate failing to implement security measures. So here, one distinction that we can draw is when it comes to personal data, if there's a wrongful disclosure of the same, then a penalty of INR 5 lakhs will apply. But when it comes to SPDI, given the criticality and given the sensitivity of the information, the legislation has prescribed that this compensation be uncapped. So it will depend on a case-to-case basis. It will have to be determined on the basis of the harm that has been caused to an information provider. So there are specific rules to govern sensitive personal data or information, which have been published pursuant to the Information Technology Act. So let's see what these SPDI rules tell us. It begins with the fact of collecting SPDI. How should one go about collecting SPDI? Collection of SPDI has a prerequisite to it. What is it? This prerequisite is the fact that an entity which wants to collect SPDI will have to publish a privacy policy on its website. I will take you through the constituents of a privacy policy. So it will give you an idea of what a privacy policy must include. The other important things that the SPDI rules deal with is how will data be collected? What will be the consent mechanism involved when one is attempting to collect data? What is the information that I will have to provide to an information provider at the time of collecting their consent? When it comes to transferring or disclosing this SPDI further, what are the steps involved then? What is the consent requirement involved in such a scenario? And then again, what are the security practices that an entity will have to implement since it is dealing with and handling SPDI? And then again, there's a requirement of appointing a grievance officer. So in case an information provider faces any issue or has any complaints about how his or her data has been dealt with, the grievance officer will come into the picture and will redress these complaints. So privacy policy, this is the first requirement. A privacy policy will have to be published on the website of the company so that it is easily available and easily accessible to information providers. A privacy policy will have to give out certain details. So under the SPDI rules, there are certain data sets that you have to mention in your privacy policy, which will include what are the categories of information you're attempting to collect, what are the purposes for which you will put this information to use for, And then how will you go about transferring your personal information? Who will be the recipients of such information when transferred? What are the rights that an information provider will have when it comes to their data? Will they have the right to access the data, review the data, correct the data, update the data, and also withdraw the consent for the SPDI that they have given? How long will the personal information be retained? What will be the security measures that the company has implemented, and the name and contact details of the grievance officer? So these are certain things that a privacy policy must include. When we go about drafting policies for our clients, we engage in a conversation with them to try and understand what are the information categories they collect, what are the purposes for which they will use it, like what is their internal transfer mechanism. All these information we have to collect and we have to assess when framing a privacy policy. Again, like, we have to put on our lawyers caps and we have to make sure that the privacy policy is drafted in a way that it's lucid enough for people that it is targeted for should be able to understand it simply. Yes, so this was the privacy policy best practices. Now coming to the consent requirement. Consent for sensitive personal data has to be a prior consent, which can be either taken in a written form or any electronic mode like a checkbox mechanism is also fine. So again, like going back to personal information, I had like pointed out the fact that under the law, for personal information, there is no consent mechanism which has been prescribed. The manner in which consent has to be taken is not prescribed, but the SPDI rule suggests how consent has to be taken for sensitive personal data or information. The fact that it has to be an explicit consent. When you're taking such consent, you have to make sure that you're informing the information providers of certain facts, like what information are they actually giving out to the company? What purpose will such information be used for? What all entities will receive access to such SPDI? So these are certain important facts that you have to make sure as a company you inform your information provider. Again, next we move on to disclosure and transfer of SPDI to third parties. Any disclosure or transfer of SPDI to a third party has to be coupled with consent from the information provider. If consent is not the basis, then it can already be agreed upon in an agreement between the information provider and the body corporate which is collecting the SPDI from the individual in the first place. See, one important aspect that we have to consider, and we do this transfer impact assessment for a lot of our clients, that when we try and transfer SPDI to a third party, whether in India or outside, what is one important fact that we have to keep in mind? It is that the entity which will receive the data, like whether in India or outside, has to have equivalent data protection levels as we have in India. Like today, I cannot, like there will be restrictions on me if I want to transfer my data to a company which is in say X country which does not have any data protection laws. Then that is a country to which I should not be transferring data to because it does not have equivalent levels of data protection. Again, the SPDI rules emphasize a lot on purpose limitation. By purpose limitations, what I mean is that any information that needs to be collected, any SPDI that needs to be collected should only be collected to the extent it is actually required by the company and it can be lawfully used by the company. Hence, one should not over exceed their attempt at collecting SPDI from individuals. Every SPDI collected should be linked to specific purposes under law. Grievance officer, I have already spoken about it earlier. The name and the contact details of the grievance officer that a company has appointed will have to be made available on its website. A lot of times, as a practical solve, what companies do is that they mention these details as part of their privacy policy itself, or some others have a separate tab for grievance officer on their website. A grievance officer is required to redress whatever complaints come their way within a period of 1 month. With this, I conclude SPDI rules and what we have in India currently when it comes to data protection. Next, we move on to the Digital Personal Data Protection Bill 2022 and this is a legislation that I'm guessing all of us gathered here are looking forward to. To give you some background, there have been almost 5 iterations of a dedicated data protection legislation that we have seen in the past, whether it be the 2018 draft, the 2019 draft, and the revised 2021 draft. So there have been several iterations, and as on date, we do not have a finalized legislation in place. But on 18th November 2022, the Ministry of Electronics and Information Technology released a draft bill called the Digital Personal Data Protection Bill 2022, which, if passed in the Parliament, will be India's first dedicated data protection legislation. Coming back to what I had said earlier, right now, if you look at the legal framework when it comes to data protection, it is just a patchwork of laws. There are like certain sections within the Information Technology Act which provides for many other things like cyber offenses, electronic signatures. So SPDI and personal information is just a small part of the IT rule. But if this Digital Personal Data Protection Bill comes into effect, then that will become India's dedicated data protection legislation, like, for instance, the GDPR in the European Union. So let us now see what this Digital Personal Data Protection Bill will apply to and its territorial scope. This bill will apply to personal data that is collected online and personal data which is collected offline but is then digitized. So let me explain this to you. When we looked at the SPDI rules, we saw how the emphasis was solely and largely on sensitive personal data or information. But if you look at this bill, it has not drawn any distinctions or separate subsets between personal information. There is no category called sensitive personal information or critical personal data under this new bill. We only have one data, which is personal data. So if today I'm collecting data from you through the internet, online, that will obviously trigger the applicability of the proposed bill. And suppose I go to a store, I'm doing some survey, I ask you to provide me your data through physical form. But then after you give me all those details in the physical form, I come back and I feed in that data that I received into my laptop. And now I'm storing that information digitally. This digitally stored information will also trigger the applicability of the new bill. Again, suppose there's a foreign entity which is offering its goods and services to individuals in India, to data principals in India. Data principals in this context would be persons from whom data is being collected or who are giving their personal data. So if a foreign entity is providing their goods and services to India, either by setting up shop in India or through an online mode, and by way of providing such services and goods, they're also collecting and processing our data, the app bill will also apply to them. And if there's any profiling that takes place of data principals in India, again, the applicability will trigger. Moving on, let us now look at some of the key highlights of this new bill. If any one of us has read the 2021 recommendations by the Joint Parliamentary Committee to the Data Protection Bill, one would see that it had said that even non-personal data has to be covered within the scope of India's data protection legislation. But this new bill does not suggest so. This new bill only deals with personal data collected online or offline, but then digitized. Again, like I said, there is no separate categorization of data into sensitive or critical categories. There's just one data. Compliances are the same for personal data. There are no heightened compliances for sensitive or critical person. Again, one important fact, and it's very interesting to note here, is that if you look at the GDPR, there are various mechanisms through which transfer of data can take place. There are standard contractual clauses, there are binding corporate rules, there are many avenues. But if you look at what the new bill has suggested for us, is that data can, like personal data of individuals in in India can only be transferred to those jurisdictions which have been pre-approved by the Indian government. So what has been said is that when the bill, if it gets passed in the parliament and comes into being, at that during that time frame, maybe we can expect a list of jurisdictions which the Indian government will approve for us to transfer data. Again, I will take you through the privacy notice requirements and the consent requirements under this new bill. But one important fact to keep in mind is how this new bill proposes to deal with children's personal data. In this case, children, like until you're 18, you will be considered as a child under this new bill, and there are several restrictions which have been imposed on entities which want to process children's personal data. Like, you cannot send children targeted advertisements. There is a complete ban on profiling of children. So there are these specific compliances that will apply if an entity is in the business of collecting or processing children's personal data. Again, I will come to this aspect of data breaches. What if a company faces a data breach? What does the new bill say? The new bill says that you come and report the fact that you've had a data breach at your entity level to us. To us, in the sense, the Digital Personal Data Protection Bill 2022 envisions setting up of a dedicated adjudicatory framework, which will be taken care of by a body called the Data Protection Board of India. So what this law suggests, what this proposed bill suggests is that whenever a company faces a data breach, you come and report the same to the Data Protection Board of India, and also to the data principals whose data has been so breached. Now, the one concerning element that we as lawyers have been able to figure out from this is that the data protection, that the new bill does not say if such reporting has to be only done for severe personal data breaches, or maybe personal data breaches which are very material. So does that mean that every time there's a data breach, however insignificant, however minor, do I have to go and report it to the Data Protection Board of India and to the data principals? Going by the language in the bill currently, it seems so. But that is the position. This can be a practical challenge for companies out. And then again, I think all of us have read in the papers already that this new bill imposes such high financial penalty. So that is again a very interesting thing, and we will have to see how the jurisprudence around this evolves. So coming to the prior notice requirements under the new bill. So this prior notice requirement that you see under the bill is equivalent to the requirement of publishing a privacy policy. The SPDI rules suggested that you publish a privacy policy. What does the new bill say? That you bring out a prior notice. You provide to individuals a prior notice. This notice should give them information on what are the personal data categories that are being collected from them at a particular time, and what will the purposes be like. Just these two things will have to be informed to the data principal while collecting this. A small distinction I would like to draw here. If you look at the privacy policy constituents under the SPDI rules, it also suggested that you have to inform information providers of the security practices that you're implementing to safeguard their data, the disclosure policy, but the new bill does not go into any of these aspects. The new bill also has come up with a very interesting provision which says that for personal data which was collected prior to this bill coming into effect, you don't have to collect fresh consent. There is no requirement to collect fresh consent, but you make sure that you send them a notice. So once this bill comes into effect, what companies will have to do is, the companies will have to issue notices to all the individuals whose data they already have. The requirement and the compliance challenge is significantly low here, because you're not asking them to give fresh consent. This is just a notice requirement, you may say. Yes. So the DP bill, so the new bill, the 2022 bill has envisioned two legal bases for collection of personal data. One is a data principal's explicit consent and deemed consent. I will come to deemed consent later, but firstly, let us look at the explicit consent. Consent will have to be specific, freely given, informed, and unambiguous. That means you cannot coerce any data principals to give you consent for their their data. Also, whenever whenever you're taking consent from data principals, one thing that you have to make sure of is that you also allow them to withdraw consent, and this process of withdrawing consent should be as easy as the process of taking consent. So you see, the reason why withdrawal of consent is such an important fact is that no personal data of individuals should be used without their will in it. Without their voluntary will in it, you cannot process personal data, and therefore allowing data principals to withdraw their consent becomes a very important part for companies. Apart from explicit consent of data principals, one more ground based on which data can be processed under the new bill is deemed consent. Deemed consent, the word suggests that you will deem that consent has already been given. You will believe that consent has already been given. And they've also given a very interesting example. Suppose you call up a restaurant. You want to book a reservation in a restaurant. Your friends and you're going out for dinner. The restaurant will obviously ask you for your contact number. So whenever you come, I'll call you whenever your reservation is due. So this information is something that one would generally expect a data principal to provide. That is exactly what the first point is saying, that where data principal is expected to voluntarily provide personal data for receiving any services, that it is so obvious in these circumstances that data will be given that one can actually rely on deemed consent. And then if there is a requirement under law, or if you have to respond to any medical emergencies, deemed consent can be used. Obviously, if somebody is like in a critical condition and there is some help that you can do, but for that you need some information about their maybe blood group or something, you will not wait to take consent from the person, right? You will assume that in such circumstances, you can go ahead with processing of their data. Even though blood group is somebody's personal data, you can use that information and you can go about maybe arranging blood for that person, even though you do not have consent. Again, for employers, this the consent mechanism framework has been simplified, because as employers, you have to have databases of your employees where you will collect their address, their contact details, and a lot of other information. But given the relationship between an employer and an employee, if such collection of information is based on explicit consent, then it may hinder the performance of the employer. And therefore, deemed consent has been allowed in such a scenario as well. Yes. So what is a data fiduciary? A data fiduciary is basically your body corporate that is collecting the information. Data fiduciary is the entity which will be responsible for all the compliances when it comes to collecting your data, safeguarding your data, ensuring that they have given you prior privacy notice, they have collected proper consent. So there are a set of obligations that the data fiduciaries will have to meet when it comes to processing personal data under the new bill. I will not go into so much details. I will try and keep it crisp. So the thing is that the most important thing here is that you have to cease retaining any personal data once the purpose for which you had collected the data is over. So the new bill also emphasizes on purpose limitation, like we had seen under the SPDI rule, that do not retain data forever and ever, because this data belongs to individuals. Retaining it forever and ever can also give rise to security threats and the possibility of a data breach. So what you do instead, what companies as best practices and also under law should do is they should have a data archival and retention policy where they will determine that if they're collecting certain data and there's a specific purpose attached to such collection, and the moment this purpose is over, the moment this purpose is achieved, they should delete the data or destroy the data. Again, one other important compliance obligation for the data fiduciary will be that they will have to give contact details of a particular person in their organization who can be held, who will be given the responsibilities of responding to questions and complaints that data principals may have when it comes to their data. as data fiduciaries, these companies engage a lot of data processors. Data processors are entities which process data on behalf of or for the data fiduciary based on their instructions. So whenever a data fiduciary is transferring such data to a data processor or maybe even another data fiduciary for that matter, they will have to make sure that such transfer is happening pursuant to valid contract. From a legal perspective, these valid contracts become very important because this is the base of any legal challenge as well. So you have to make sure as lawyers that this contract includes robust safeguards, restrictions on what the data can be used for, how the data has to be stored, how the data has to be secured. So by way of this contract, the data fiduciary is basically laying out certain ground rules and certain security measures that data processors will have to comply with when dealing with data that they have received from data fiduciary. So yes, there are a couple of obligations like this. Again, let's come to the aspect of data principles a bit. It is my data. I have given my data. What is the right that I have in respect of such data? Yes, the rights that a data principal will have is that the right to be informed about whether my data has been processed or not. If yes, I can ask for a summary of what data has been processed about me. I can also ask for identity details of all the other data fiduciaries who have received access to my data. So basically, I have the right to seek information about how my data has been used. Right of grievance redressal, we as data principals, if we have any complaints or grievances in respect of how our data is being used, there should be a readily available means that the data fiduciary should provide. This is also one of our rights. The next right is right to nominate. So this is a unique concept that the DP bill has introduced, and we also saw something on similar lines in the 2019 bill as well. That in the event a data principal passes away, in the event of that person's death, I have the right to, prior to my death, of course, I have the right to nominate another individual who will, after my death, be able to exercise rights in respect of my data. So suppose like a company like Facebook, I have my account on Facebook. And what if something happens to me tomorrow, I die? I get a right to nominate another individual who, after my death, will be able to decide whether to continue with my Facebook account or to delete my account. So this person will have the right to exercise rights in respect of my data. Again, the next right is very simple, but very important. Right to correct and erase personal data. If I feel certain information about me that has been collected is incorrect, I can reach out to the data fiduciary and get that information updated, corrected, changed. And if I feel that a certain set of facts about me is no longer required, or I do not want to provide this data any longer, then such data can also be erased. And that can happen pursuant to a request I make to the data fiduciary. Another important aspect that the new bill has provided for is that there are data fiduciaries, but then there will also be a category of significant data fiduciaries. Significant data fiduciaries will be data fiduciaries which will be recognized by the central government as such, by the Indian government as such. And basically, these will be data fiduciaries which deal with large volumes of data, or the kind of data they collect is so critical that anything that goes wrong with such data can be riskier, very risky when it comes to data processed by other generic data fiduciaries. For instance, today, any social media platform like a Facebook, like a Twitter, can become a significant data fiduciary by virtue of them processing so much data because of their user count. So yes, when it comes to significant data fiduciaries, the compliances will be as is that data fiduciaries have, but there will be some additional compliances as well. Additional compliances would include appointing a data protection officer who will be based in India. This is one requirement. Also, significant data fiduciaries will have to appoint an independent data auditor who will evaluate if such significant data fiduciary is actually in compliance with the provisions of the new bill. And also, if required by the Data Protection Board of India or if ordered by the central government, significant data fiduciaries would also have to undertake data protection impact assessment. Like I had pointed out in the very beginning in respect of the new bill, it envisions setting up of a data protection board of India. This will be the adjudicatory body which will basically evaluate non-compliances of data fiduciaries and significant data fiduciaries under the new bill. So as an aggrieved data principal, if I have complaint, my first recourse is to the data fiduciary. That if I have a complaint, I write to the data fiduciary that so and so is my complaint, please redress. I do not receive a response. What is the next step that I can do? I can register a complaint with the Data Protection Board of India. The Data Protection Board of India will obviously take up my case, and then if the decision that the Data Protection Board of India is also something that I as a data principal am not that comfortable with, I also have a right to appeal within 60 days to the High Court of India, and then the process of law will follow. The Data Protection Board of India also has the right to suo motu take cognizance of non-compliances, or it can proceed on the basis of any complaints received from the government. So these are the penalties. See the penalties that have been prescribed for different categories of non-compliances. The penalties are quite high. But one important factor that we should keep in mind is that this penalty amount is not a fixed amount that will be imposed every time there's a non-compliance. This penalty amount will be decided by the Data Protection Board of India on a case-to-case basis and on the basis of certain factors like how grave was a non-compliance, what was the duration of the non-compliance, is the non-compliance repetitive and intentional, has the data fiduciary which has which has not complied with a particular obligation taken any efforts to rectify this. So basically, these are the mitigating factors that the Data Protection Board of India will take into account when deciding the quantum of penalty. So coming to the more practical side of the new bill, if it comes into effect, there are a few things that we as lawyers will have to advise our clients on. That what are the next steps? What do we do? So let's look at the check boxes that we will have to tick. We will have to make sure that we are providing a privacy policy to them, which is simple, which is lucid, and which has the information that requires to be furnished. That is the kinds of data I propose to collect and the purposes for which I propose to collect. The next one is the mechanism of consent, of taking consent and withdrawing consent has to be enabled. It can be through a simple mechanism such as a check box, also like a tick box. Under the new bill, it has been said that the burden of proving that a data fiduciary had taken valid consent will lie with the data fiduciary, and hence it is important that data fiduciaries retain this evidence, retain record of consent having been collected, privacy notices having been given to data principals. All such records should be maintained so that if in a court of law we are called on to produce such evidence, show that we were rightfully processing data, we should be able to provide this. Again, we come to data principals' rights. We have to make sure that data principals are being allowed to access and exercise their rights. When it comes to consent for processing children's personal data, this consent has to be taken from their parents. And for this, we have to ensure that this is a consent mechanism that is coupled with verification. Like today, a lot of times it happens that a child just pretends to be over 18 and, they access sites which ideally should not be accessed by children. What this new bill suggests is that you, as companies collecting the data, be responsible. Make sure that this consent is just not mere consent, but it is verifiable consent. Like you send an OTP to the parents that they have to provide. Only then can this consent be considered as verified. Again, one thing that the DP bill imposes as a compliance obligation, which could be a challenge, is to publish the privacy notice and the consent request in almost 22 languages that the 8th schedule to the Indian Constitution suggests. Another compliance would be to make sure that you have appointed the officers that are required under the bill. And then I have already spoken about valid contracts. Make sure that as a data fiduciary, you have ticked these checkbox when preparing for the new law. Yes, so another aspect of this presentation was to cover cyber security and the legislative framework around it. So let me just give you a little bit of the background. Cyber security incidents are incidents which can include data breaches, data leaks, phishing attacks, hacking, ransomware attacks, and a lot of things. So we actually have a body which has been constituted again under the same act, Information Technology Act of 2000. And this body that we had constituted was the Indian Computer Emergency Response Team. This is the body which is tasked with the responsibility of handling and responding to cybersecurity incidents in India, in making sure that entities are doing what they can to counter such attacks. So there are rules specific to the CERT-in, like the Indian Computer Emergency Response Team is called CERT-in, abbreviated, it's called CERT-in. So the rules used to suggest, the 2013 rules used to suggest that whenever an organization undergoes a cybersecurity incident, they may report it to the CERT-in as soon as possible for them. So here we see two things. It was not a mandatory reporting requirement, and the timelines were also not that stringent. They said you may report, and such reporting may be made as soon as practically possible. This was provided in 2013 as part of the rule. Then again on 20th January 2021, the CERT-in released an advisory. It said that whenever a data breach or a data leak happens, make sure you report that to us immediately. And they also brought out a certain format in which such reporting could be done, which can be found on their website also, certain reporting form. And it also went a step ahead and said that you not only inform us immediately, but you also inform to all the users and all the customers whose data has so been breached. So gradually we see how the CERT-in has started to make its cybersecurity regime more stringent. Initially from a voluntary reporting mechanism to a mandatory immediate reporting mechanism, we see how the cybersecurity incident reporting and handling in India became more and more stringent. But the most important thing that happened to India's cybersecurity framework is a direction which the CERT-in released on 28th April 2022, which is obviously not, it's quite recent. 28th April 2022, and this direction came into effect within 2 months of its release. This direction by the CERT-in has changed the entire landscape when it comes to cybersecurity in India. This direction is applicable to these entities. It will be applicable to body corporates. Body corporates is a very widely defined term under the IT Act and will basically cover all entities which are doing any kind of business in India, commercial or any professional activities in India. It will also include foreign entities which are offering commercial or professional services in India. Service providers, it also includes intermediaries, it also includes data centers and government organizations as well. So let's look at what are the compliances look like under this direction. This direction has basically given us an exhaustive list of certain cybersecurity incidents which, if has occurred in a particular organization, the same will have to get reported to the CERT-in within 6 hours. So when the direction came out, it sent a lot of body corporates and a lot of, it was very concerning for businesses that how do I report a data breach in 6 hours? Because when a data breach happens, when a cybersecurity happens, when a ransomware attack is happening, you're constantly trying to gauge the impact of the attack, what all systems have been impacted. You're still trying to negotiate with the ransomware, the person who has attacked, the hacker. So this is a legal obligation that whenever you notice a cybersecurity incident or you are brought to notice about a cybersecurity incident, within 6 hours of that, you make sure you mandatorily report it to the CERT. It also says that there are a lot of ICT systems that we use in our daily lives and working. ICT systems is information communications and technologies. So what this obligation suggests is that you have to synchronize your ICT system clocks to specific system clocks of the NPL and the NIC. NIC is the National Informatics Center and NPL is the National Physics Lab. So why this requirement has come about is because, whenever a data breach has happened or a cybersecurity incident has happened, there are timestamps that are very important. That when has this occurred, to what time frame did this continue for. But if entities today, like today, suppose I use AWS, Amazon Web Servers, and some other entity uses some other servers, there is no parity. So what this direction wants to do is they want to impose a uniform time synchronization system.
So thing is that, see, until it was informing people about informing the certain authority about a data breach, the impact was much superficial. So tomorrow you open the newspaper and you see that a breach has happened at the Ghana.com's servers. It's still not that impactful. But imagine someone notifying you tomorrow that your data has been breached. The havoc that it can create is massive. I mean, then people come to know. It's like some incident happened in the school and someone is saying that your children is not safe. The impact is much more public and much more personal, and so that's why it created all. When this certain advisory came in, when the companies realized that the impact that will have on their on the data, they just lost it. So first and foremost is to understand what an intermediary is, and this has been a long run discussion between me and Sharmana. Most of the time, people falter to distinguish between a normal website and intermediaries. So intermediaries always remember that there are three-person involved, and this entity is always like a platform. So for example, I am transmitting some data. Malvika here is receiving the data. The medium that is being used, the platform that is being used to exchange this is called intermediary. So here the intermediary is say the Zoom app is the intermediary. So that basic distinction has to be understood. Unfortunately, most of the times even the legislators fail to understand the and legislate accordingly. Second is publication on the mobile website. So under the intermediary regulations also, there are traces, as I was saying, of obligations about the privacy policy. So even the intermediate regulation says that you have to publish the privacy policy and it has to be published in n number of languages. Now there is a problem issue with the drafting of this particular section. It says that it has to be in English or any language specified under the 8th schedule of the choice of the particular person. Now this makes the interpretation a little bit more complicated, because see, if the idea is that people are able to read these privacy policy and terms and conditions in their own language, then it should be English and any other language in the, or say X number of languages in the choice. But the word uses or, and the number of languages specified in the schedule is 22. So imagine, and a person who has to publish a privacy policy or a terms and condition on the website has to duplicate it in 22 different languages. And when this piece of legislation came in, we were superbly perplexed as to what the government was trying to say. Ideally, every privacy policy bit is in English and generally in English, and then you can say that it can be like, and if say for example, instead of this word or, it says that English and say any 3 languages specified in the schedule, whatever. Later on, we understood the intent of the government is to make sure that the privacy policy is published in English and say in the language which is predominantly, which is for which the app has been created. For example, you are in a Bengali streaming app, and it is expected that the privacy policy will have the terms and conditions and the privacy policy in Bengali. Second is ensuring compliance with the content standards. Now again, government, as I was saying, the legislator are trying to are trying to cram everything in this legislation. They have made this intermediary guidelines. I mean, it's a behemoth in itself. If you take it up, it's like some 32 pages legislation. And now there is a law pertaining to disinformation or misinformation included in this as well. So this again, fact checking aspect has also been included in this, where the user have to be aware about what information he or she is publishing and have to do a fact checking to ensure that it is not false information, it does not promote enmity, incites violence, and etc etc. Then obviously there is a requirement of informing the users about the privacy policy, the terms and conditions, at least once a year by the particular intermediary. And last is the takedown of the information, that is with money. The certain time period has been specified within which a non-compliant information will has to be taken down. An intermediary will have to preserve the records for certain number of days. That Sharmana has also said that this is very important because entity, I mean, the regulatory authorities can specify the regulatory authorities can come back asking for that information. Then it has to be taken down within 36 hours, and then the grievance redressal mechanism under the intermediary guidelines is a separate procedure altogether. And last is that any kind of assistance has to be provided to the government within 72 hours. That is basically it from an intermediary liability perspective. Yeah, I think that's it.
Now, the first question is regarding prior notice and consent. It touches both of these aspects. There are, you mentioned two requirements. One is what is the information that is going to be collected?
Yeah.
And the second one is the purpose
Yes.
for which it is going to
Yes.
be used. Okay.
Right.
Now, I'm just wondering, isn't there any requirement, or probably is it still not too late to bring this up with the government? Apart from the data being collected and the purpose, can we not know what is the justification also for the collection? Because if you see many times when you're going to a website or you're installing an app, you are forced to give permission such as location and share your contacts, which cannot be justified. So if you want, so indirectly you're not giving consent really, because you're forced to do it, and there's no justification. If the app has got nothing to do with your contacts, but they are still forcing you to share your contacts. So that's what I wanted to ask you regarding justification apart from these two factors.
Oh, yes. The thing is that so far, from an Indian data protection law perspective, the enforcement for non-compliance is not very rigorous. And like I had started my session with this, that when we deal with clients, a lot of times they come back to us and tell us that they were not even aware about the existence of these SPTI. So yes, when it comes to securing data and when it comes to implementing a proper data protection framework, companies in India have lagged. But this may soon change once the DP bill comes into being, because then what will happen is with the penalties getting more stringent, it will act as a deterrent factor. So going by this, we can actually expect the privacy notices, which will now be a requirement to be published, to be more detailed. Again, we will have to see how the DP bill gets implemented. What is the nature of privacy notices that companies come out with? But if this DP bill is enforced properly, like how it is envisioned to, then we may actually see the excessive collection of personal data by a lot of companies kind of taking a hit. Like obviously we sitting here today will not be able to gauge what will happen in the future, but yes, the financial penalties are definitely a deterrent. And if today any data fiduciary is called to the Data Protection Board of India and asked to justify before them why they were collecting location data when that was not required, they will be in a fix. So the lawyers advising these companies will have to basically speak to them and tell them that, see, only if you have like a specific purpose connected to the requirement for a particular data category, only then go ahead and collect it. Do not indulge in excessive collection of data. So yes, we can expect things to improve in the data protection scenario. But yes, sitting here today, we will not be able to
Yeah.
conclude, conclude on anything
So my question
concrete.
was, as of now, there is no requirement for them to justify. So like if
I
a
think
social media, if a,
justification would then get equated to purpose, that whatever purpose you're
no,
suggesting to the
he will say he
data
will give some
principle.
purpose. He will give
Yes,
like
yes.
a social media app. Supposing they
Right,
ask me
right,
to give
right.
my blood, if
See,
they ask me
I
to give my
feel
blood
this is
group.
how data protection as a jurisprudence will evolve in India. I'm sure a lot of challenges will be thrown at these companies that you just cannot give to me a flimsy ground for collecting my data. And then maybe the Data Protection Board of India will step in. We will see some jurisprudence developing around this area that just do not end up with any flimsy ground. You make sure that whatever data is collected is connected to a business purpose. You have to justify it. But right now, under the black letters of the new bill, there's nothing. But yes, there is a provision for further rules to be prescribed. So we can expect more prescriptive compliances coming out by way of the rules. So we can look forward.
Justice B.N. Sri Krishna did think about it, and he included a section in the initial bill, the first bill that came out, which was drafted by Justice B.N. Sri Krishna, that it has to be a reasonable ground for processing data. And he also
Okay.
included, basically, he set out the jurisprudence that you cannot go on a spree of collecting data. I can't exactly remember the language as of now, but what I have understood, or what I remember, is it has to be reasonable, and it has to be a valid ground for processing the data, basis which you're seeking the data. You cannot just go on asking for that particular set of data, right, Sharmana? If you
Yes,
remember
yes,
that bill
yes,
that came out, initial
yes.
bill, it had a very beautiful language, and
Right.
he clearly distinguished between the European GDPR, how they had not thought about it, and our legislators, when initially the draft was being drafted, they had thought about it and saying that it cannot be just a lawful purpose, or it has to be reasonable at the same time. I cannot ask,
So
say,
why was it dropped?
yeah, so for example, this is a famous SIM card company. I will go on a no name basis, but the famous SIM card company collected data on, I think, religion of people, and people, it was all over the social media. They were being bashed left, right, and center, that why will you need data like this to operate a SIM card? So it is also about when this data awareness comes into the picture, it is also about the public shaming that you will have to face for unreasonably collecting data. And the second thing is, obviously, we still under the data protection bill, the language used is a lawful purpose, and you cannot keep go on as I said, that the data, he will have to, the entity will have to justify the purpose. If you see, there's a section particularly which says that there has to be a particular purpose for which you're collecting the data, and if you can't justify that purpose, then basically that falls flaw of the very first section of the bill, that you've collected without a lawful purpose.
So why was it dropped? Why was Justice Sri Krishna's dropped in the subsequent bill?
I mean, yeah. So see, there was a lot of
Like there were
conflict.
several iterations also in
Uh,
the bill, and obviously they've
I mean, it was a
held
good draft, no doubt.
consultations. Yes.
It was a very good draft, no doubt. But again, in a political tandem, few people will
Yeah.
agree to you, few people will not. I mean, that you cannot help. And we as lawyers, we are very impartial as to what. I mean, all we are looking forward to is the end product that will come out as the act. I mean, can you really complain about what has gone into the constitution?
No. So no, as a lawyer, either way, it is good for us. We will make money both ways. So, but I was just curious about why this requirement was not there as a consumer, not as a lawyer. Okay, coming to a data fiduciary, you mentioned two kinds. One is a data fiduciary and one is a significant, if I remember the
Yes.
word correct.
Yes.
Yeah. Okay, now the normal data fiduciary, is there, for that also, is there any threshold? Because I'm just saying, supposing I run a very small business,
Yeah.
okay, like a small restaurant or something, just mom and pop kind of a shop,
Right.
and I'm a data fiduciary because I may be collecting certain data. So are all these rules going to be applicable to me? Do I have to also appoint a data protection officer? Do I have to enter into contracts with my website hosting people where data protection is mentioned? Is there any threshold, or like it absolutely applies to everyone?
Yes, there is no threshold when it comes to a data fiduciary. Any person, any entity which is dealing in personal data, processing personal data in an offline, but then digitized mode will basically have to comply with the provisions of the bill. But then yes, the data protection officer appointment requirement is specifically for significant data fiduciaries. What data fiduciaries, like general data fiduciaries, would have to do just to have one person named on their website who can basically redress complaints that any data principal may have. So when it comes to significant data fiduciaries, the obligations are a little more stringent, not so much so for generic data fiduciaries. And yes, see, it will depend on the nature of business you are in. You don't have to enter into contracts with data hosting a website for the purposes of your data privacy compliance. Only if you're sharing data with a third party entity and that entity is processing such data for you. If that entity falls into the shoes of a data processor, or you are sharing data with another data fiduciary, then of course you will have obligations around entering and maintaining valid contracts. See,
But
this will also
isn't the
save you.
website host also a third party?
But it also depends on what is the category of data that you will end up sharing with the website
All my
hosting
customer data,
entity.
my entire customer data.
If you end up sharing that, then yes, you will have to make sure that you have proper contracts in place, because see, that is that, to my mind, having this kind of a contract requirement is a win-win situation, right? Because if today anything goes wrong and there's a challenge, you can rely on this contract and say that I had asked my data processor to undertake
Yes.
so and so safeguards. I have audited and all of that, but then that person has not done so and so. This was a fact that was not
Yeah.
disclosed to me. So this will be a win-win for both parties. Like, you can also have you have to make sure that you are not held up for this, and for this purpose, you can rely on the provisions of the contract and say that I had put in my reasonable efforts to make sure that this contract is robust enough. And even for the
No,
data processor, no,
there
no,
was a
please go ahead.
reason I was asking this question.
Oh, okay.
Because if what you're saying is true, if just about every
Yeah,
proprietary
like
concern,
right now, there is no such threshold. Yes. I mean, there is
yeah.
not
So
likely
if
to be any.
everybody is going to, so if everybody is going to require to follow these rules,
Yes.
this is going to be like a bonanza for lawyers in this area. Like
Yes,
it's,
right,
I
right,
mean, in the
right.
days to come, once this bill is passed, there's going to be so much of business you will not be able
Yes,
to handle it all.
absolutely, absolutely. So data protection is definitely an area of law which will tremendously grow.
Hi, this is Meet here. I am just curious to know that in the existing laws in the IT sector, what is the take on the WhatsApp privacy policy, which
Uh,
mandates sharing of the data with the Facebook and the group companies?
yes, so let me tell you, like, we deal with a lot of clients and we vet their privacy policies. One standard clause that we end up seeing is that they have clauses to say that they can actually go ahead and share personal data of customers within their group entities. That is the clause. You like open up any privacy policy on the website and you will find it there. It is a very standard clause to have, and this has developed like as a
Oh,
market practice, really. Again, like, going back to Sushil sir's concern, that these because of the fact that data protection laws in India has not been that enforcement has not been that robust, there are times when companies have not been able to justify real grounds for sharing such data within entities. But yes, this continues to happen. And I think this matter was also taken up by the CCI as a competition law concern. And yes, we are all aware of the judgment that was given thereafter. But yes, I think with the new DP bill coming in, we can expect things to improve. Obviously, it will not happen from day one. People will take their time to understand how to go about the compliances, how to practically solve for the challenges that the compliances pose, and then gradually with discussions with the Data Protection Board of India, with the decisions they roll out, we will have to understand how the data protection jurisprudence evolves, and then we may actually end up seeing an order one day which says that you have to make sure that whatever data you're collecting or sharing with third parties is justified. So, like right now, if you ask me, this is a very standard clause that you will find in any privacy policy that you look up on the. It's a very
Uh,
standard clause to have.
but just addition to the same,
Yes.
WhatsApp has all can say like daily updates from sins to good deeds of a person on over it, and then leaving it subject to processing of the WhatsApp. They have like the most personal and the sensitive data one can say in terms of psychology or say banking. So allowing them to have a third party sharing rather than any other Zomato, Swiggy, or any other website for the said purpose. It's a huge difference over there.
Yeah,
So,
I
and
agree with
what
you.
am I
But
able
then, if you look at Facebook's arguments also before the CCI, they were able to make a case for themselves and basically justify that whatever data is coming their way, that will be used for specific purposes. It is not over excessive. So obviously, when these things go up for challenge, that's where lawyers like us come into the picture, and we have to, like how Supallab said, we have to be impartial and represent both sides to the best of our abilities. And obviously, we will have to figure out practical solves. So, yes, I can leave you with
even
that thought. Yeah.
even Kulmaya Singh case is there in the High Court, which allowed the users' prior data to be deleted and allowed to continue WhatsApp with the new privacy policy for the new users. And it
Yeah.
is pending before Supreme Court at present with the
Yeah.
data privacy bill and
So, let's see if the Supreme Court, has something in store for us.
Okay, ma'am. Thank you. But in case of other laws which we discussed today, can you just
Yes.
give a brief idea of which may be a relevant section if we go saying that it is not a lawful contract, or say it has been coercion, or
See,
it is
I
a
don't think it will
stalking of
flow from the bill.
IPC?
It's a contractual thing, right, Sharmana?
Yes. Like,
It is unconsignable
there's no
consent.
real section for
It will come under the unconsignable consent. Basically, if something like this happens, say hypothetically, not in a WhatsApp scenario, but say any other person doing it and has not taken your consent and has just decided to transfer the data, it will come under unconsignable consent.
Can we go for the stalking in IPC? Like it is though related to women, but cyber stalking can also be a thing.
No. This
Which
is
let
nothing
me
to do with stalking.
Okay, so my question was, you mentioned the right to withdraw consent, but you did not mention the right to be forgotten like you have in Europe. Can you say something about that? Is it there in the bill?
This version
The
of
right to
the
be
bill does
forgotten?
not go into right to be forgotten as such, but then there's a possibility for you to request for erasure of your data, but no specific right to be
But not
forgotten.
as
Like,
of right, not as of a right under the statute. I can
right to
only
be
request,
forgotten
and
is
they
not
can.
recognized as a right under the new bill. They've not provided for such a right. Yeah.
Yeah, like in Europe it is, no?
No, that's
Yeah.
a very
No.
European concept. There's a problem with that philosophically because we have a very strong right to right to information freedom of speech and expression. So we have to strike a balance somewhere. So we can have the destruction of the data and erasure, but we cannot expect the entities to go and delete data. That will technically amount to a very constitutional mess where the person's right of freedom of speech and expression is being curtailed.
No. If the person himself is asking, like you mentioned, no, like after I die,
Doesn't
I
matter.
can
So, for
nominate somebody.
example,
Yeah.
someone has written an article on you committing a crime. That is the person's speech or freedom of speech and expression.
No, I'm talking about information which I have provided.
That is erasure.
Yeah,
That is
erasure.
not
Yeah.
right to be forgotten.
Yeah.
Right to be forgotten is very wide. Right to be forgotten is you asking the
Okay, that is much broader. Yeah.
data of any information that exists in your name. That as a concept
Okay.
cannot exist in India.
Okay. So this is right of erasure. This is
Yeah.
there. This right of erasure is there in the
Yes,
bill.
that is
It's
under
there.
the bill. Yes.
Okay. And if you don't mind, see, I mean, this is not pertaining to your topic because this is only talking about digital data. But as of now, data which is offline, the only recourse is now some kind of a remedy under tort, or is there any other remedy?
But then if if you start processing that data and storing that
No,
data
without processing. Without, if it's
digitally,
only in ledger, it's in my ledgers only written, handwritten, and it is misused. What is the remedy as of now? It is not yet digitized.
then you can go under, disclosure of your personal information under the IT Act also.
72A will survive, no matter.
Yes.
So even if
Yes.
43A goes away, you still have 72A as an avenue.
Even if it is not digitized.
Correct.
Yeah, that will apply.
First one is the structure of the bill, that earlier it was minor criminal law, while this is just a civil law.
So you're saying that why there was, that is completely legislative intent, Virendra. I mean,
Well, but they have completely ignored Justice B.N. Srishna committee and even the JPC report, and how from where
doesn't matter. Again,
out of the
that
blue
is,
this new bill of
even if you are a judge
2022
tomorrow, it doesn't matter. Even to a judge, it will not matter what the legislative intent was.
And yes, like whatever we've heard from the public consultations and all, the minister has been of the opinion that the high quantum of financial penalties will be enough for deterrent.
Which is a very good deterrent.
Yeah, and they do
it
not
is not
want
like
to
you pay and get away, because it's quite substantial. 500 crores, even
nobody
for a
will want to pay a 500
even for a listed
penalty.
company. I don't think you need to put people in jail for this. It's an economic offense.
Okay, that
And
And
even
therefore,
if
they
you see,
have not suggested any criminal penalties.
in
Yes,
fact, for Companies Act also a lot of sections was decriminalized because the impact was not as much as it was fathomed in the beginning.
Okay.
It doesn't require a director to go in jail if minutes of the meetings are not properly maintained.
Well, then coming to my second question, this adverse impact on RTI Act. Why RTI Act?
I read 29 subclause 2. It doesn't say that it has an adverse impact on the RTI Act. If you are
yeah, I think Supallab is absolutely right. Like if we read the provision, it says that the amended language says that public information of officers may deny public requests for information on the simple ground that it is personal information. I do not think it is that restrictive, but yes, like consultations have happened and Supallab can throw more light on this. I'm sure the government is considering whatever assistance they are receiving
but it definitely does not have any impact on right to information, because the kind of data sought under RTI is very different from what the personal bill is trying to address.
Okay, coming to my third question, the difference between this penalty and compensation. Okay, there are no fines. There is only penalty, and the maximum limits have been specified under this bill. There is no provision for compensation.
Yes, no compensation
there.
has been.
So that means penalty goes
provided
to the state exchequer. There is no say private litigation or private compensation that will be paid like the law of torts. So why this compensation has suddenly disappeared from this
yes,
bill?
like we will not be able to answer this question because obviously we were not part of the drafting process. But yes, one thing I can tell you that as part of the public consultation, this point has actually been submitted as feedback by a lot of entities and by a lot of activists. So let's see what we get to see in the final draft of the bill. But yes, as on today's date, there's no compensation.
But even there are two types of activists. Earlier, there were only IT activists, but when this bill comes, I think there would be some privacy activists also in India.
I think we already have them.
Yes. Okay. Thanks. Thank you for your answer. Thank you. Even I have suggested online suggestions to the Ministry of Information Technology.
Yeah.
Yes, in the due consultation process. Thank you.
Thank you. Okay, so I think we are done with the questions. So just can you highlight what are the career prospects for lawyers? Like Sushil also mentioned that it's a bonanza. So can you highlight for the participants?
Not bonanza per se, but yeah, there are law firms which are coming up with teams specifically doing as well. Like Sharmana does only data protection, and I mean belongs to a team which does only data protection. And obviously there are other IT Act perspectives also which they handle. But and so while KCO is like a huge law firm, and there are the kitty is large, and you can and they have teams which specifically which goes into very niche areas of law. And similarly, other their tier one law firms can afford to do that. You will understand that this has potential when smaller law firms, I mean very smaller law firms, who are doing only IT practice as their sole practice area. And that means this is substantial business and a lot of potential when it comes to when we think of it as from the perspective of revenue. A lot of freshers who have specialization in data protection are being inducted because they have that expertise. But you have to understand one thing: because of the recent awareness drive that has happened because of this bill coming in and so many data breaches, and everyone almost knows something or the other about the data protection law or the bill. You have to have an edge over it. There are specified courses which help you to develop an expertise. And I mean, so these companies, I mean, those who are your clients, who will be your clients, have started appointing lawyers who are already qualified to say implement a privacy program in their system. So in order to have an edge over them, you have to be qualified enough to advise them. You have to, now the game is not about just knowing the law. The game is about um, understanding the market practice, understanding the intent of the government, where they are headed, and advising your client accordingly, and able to take that view and take that view basis logic. So a there is scope. B, if you are able to like work on yourself and you know uh, get those qualifications which is expected, then you're through. Then there is huge potential for this.
I have in fact started working with the data privacy team in case, so it's almost been a year, and the kind of work that comes our way is stellar. And because it's such a nuanced field, and like how Supalla pointed out, it's not enough for us to only know the law. We also have to understand if we can, give our clients what they're the practical solves that they're coming to us for. It is very important to get a holistic understanding of how can these compliances that we see in the law be implemented.
Like
We
the
cannot be.
timestamp thing which Sharmana was saying, you not only have to know the law, you have to understand the technology also. And when you're sitting across, say, across a person who is a promoter of a company, he is in all probabilities a engineer, a software engineer, and a MBA. So he'll be speaking at a wavelength where he thinks that the other person knows the technology, and he will come up with question that if this is my X is my system, then how will I implement Y in it? And you'll have to understand what he's saying and then accordingly answer. So that is having the edge. Anyone can today pick up the bill, read the law, understand it. Having deep insight of systems is something which this kind of bills, this kind of laws required. That is one thing. Second, as I was saying, see, most of the general counsels of these software companies have already taken privacy program trainings and all. They know inside out. So I mean, just to know the law is not good enough. I mean, and this privacy program, I mean, I would suggest, despite if you really want to excel in this, not only just complete I mean, not only just read the law, but try and take up this privacy program training, how privacy programs are implemented in organizations. Understand that will actually give you an edge over the others, and there are chances of you landing an opportunity is more compared to someone who has just read the law and come. Okay.
Thank